Hello and welcome back to Starting Over. I am your host, Patti Handy. So happy you're here on your lunch hour sharing that with me. Just a PS before I forget, starting next month in June, I forgot to mention I'll be on twice a month. I'll be on the second and fourth Wednesday, but I'm changing times. I'm going to 2 o'clock hour, so from 2 to 3 I'll be on from the noon hour. So make sure you mark your calendar for that. Again, Starting Over is a show dedicated for those starting over after divorce or loss of a spouse. The hope and passion is to help those navigate the time of difficult waters, both financially, physically, emotionally. My last guest speaker, we talked about physical fitness. I've got another great guest coming up that I'll introduce in a moment. But the real focus here, again, is to really help bring inspiration and hope and help you get through this time. Having gone through a divorce myself, I remember how difficult it was just to navigate life in general. Having a young child at home made it more challenging. So my hope is to really help you, encourage you, and know that you've got resources. So let me introduce my next expert speaker. Very excited to have her on. Her name is Penny St. John. She is a Stanford and Boston law graduate. She's been a member of the California Bar for over 30 years. Started her career out as a corporate finance attorney in Los Angeles with O'Melveny and Myers. I'm not sure I pronounced that right. Forgive me if I didn't. And then changed to marriage and family litigation for Troop and Troop. At that time, it was the biggest marriage and family law firm in California. And Penny saw the advantages of just having mediation only before it was really accepted as an alternative method. And she started her own mediation practice in 1997. Her firm is called Conflict Resolution Management. Her office is located on the west side of LA near UCLA. So welcome, Penny. Can you hear me?
I can. Hi, Patti.
Hello. Thank you so much for joining us.
My pleasure.
Happy to have you here. You know, I went through mediation myself, so I can attest that it certainly was a lot more peaceful and less expensive than a traditional divorce attorney route. But let's get into a couple questions that I have for you. We're also Facebook Live, by the way, so if anybody wants to ask questions to Penny, feel free to jot those in the Facebook chat, and we'll be keeping an eye out for that. So first question for you is what can a woman who expects to have a dispute about custody do to prepare for that? Because custody obviously is a very heated and emotional subject. What do you suggest for that?
Well, Patti, I encourage all my clients to keep what I call a custody journal on a regular basis, writing down the things that are relevant for, parenting that both spouses are doing. If you're the one always taking the child to the teacher, to the doctor, to that, you just keep a record of having done that, and anything that the spouse the other parent is doing that's relevant for whether they can care for the custodial timeshare. You should jot that down because it's much more persuasive, both in negotiation and in a court hearing on this subject, if you have specific instances of the behavior that should affect the custodial timeshare than just general statements like, he never put sunscreen on the baby.
He doesn't do this or doesn't do that. You have fact, and so to say that you should date it and time it and really keep an accurate record.
And I encourage people to not put it in their, not just make it part of their day timer or some other calendar. They should keep a specific journal just for these items.
Okay, that's good. Documentation is always important. That's
and then
important.
Because if you're negotiating or if you're going to court, there's going to be a time where you're going to need to explain why you believe that the custody situation should be as you are proposing, and so you'll be able to come up with specific instances if you've kept a record. Otherwise, it's hard to remember.
Sure. Yeah. Absolutely. Okay. Great advice. So financial issues are always a hot topic with life in general, let alone going through a divorce. So what do you suggest to clients to prepare for financial issues?
Well, they're usually going to come up in a dissolution matter. So really everyone should have information about their family income, expenses, assets, and debts. you're going to be required to show account statements and title documents and things anyway during this process. So, you should locate those things. If you don't have access to them already, or if you haven't been gathering them, you should begin to gather those as soon as you think this is going to be an issue. Frankly, people who are still remaining married even should have that information. It shouldn't be a mystery to you, what your income, expenses, assets, and debts are. I know you're a proponent of that too, Patti.
Yeah, I've had, more than I care to count, clients in the past in the mortgage business that's my full-time role is clients who've come to me after their spouse has passed and weren't aware of where they had their funds, didn't realize they even had funds, didn't have statements, didn't have anything, and it was just it just made it that much more difficult. And of course, the passing of the spouse, in some cases was a surprise. It was an accident, and so they didn't prepare for that. So I completely agree with your statement about even couples who are happily married should have all this in place, because you just never know. They both should be on the same page and know where everything is. Absolutely.
Mm-hmm. And you have a right to it. Both spouses have a right to that information.
Yeah.
So they should gather it.
Yeah, and it's not like one's trying to keep a secret over the other by any stretch. It's just smart. The wife could be hurt somehow, and the husband now needs to take over the kids and the finances and paying the bills and whatnot, or vice versa. And it's just fair. It's just really being fair.
Mm-hmm.
So we know that hiring an attorney is expensive, and costs can just really accelerate over time. What can a woman who's on a budget do to cut down on attorney fees?
Well, that is an excellent question, because you need to organize yourself before every attorney meeting. You need to know the agenda, what is going to be covered. You need to have the documents and the information that your attorney is going to need. You need to write down your questions beforehand and bring them with you, and then take notes on their answers. These sound like simple things, but when you're going through such tumult in a divorce,
mm-hmm.
You're not going to remember as well. A lot of your mind, like the RAM of your mind, to use a computer term, is going to be really running on a lot of different issues. So you want to be disciplined about preparing for it, having the information that you need, getting your questions down, and then writing down the answers while you're in the meeting. I could tell you a little bit more about that if you want.
Yeah, let's expand on that just a bit, because that's a really hot topic. I think that any suggestions that you can share in addition would be great.
Well, there is something that every spouse, both sides, who are going through a dissolution of marriage are going to have to do, and that is they're going to have to prepare disclosure documents. These are forms, judicial counsel forms, that cover your income, expenses, assets, and debts of both parties and of the family. So before you meet with your attorney, you should gather that information and either summarize it in a chart or a spreadsheet, or you can even download those judicial counsel disclosure forms from the internet and use those as a guide to list this information on it. Because if you end up in litigation, if you have to go to court with this and you don't have this information, you'll have to pay your lawyer to formally request it from your spouse, and they'll have to pay their lawyer to respond. So you like to have the information gathered, and then if you can summarize it, and even I think it's a good idea, Patti, to email it to your lawyer before the meeting. Sometimes you're just gathering things and you just grab it and go. Really, if you have the time to scan it and email it to your lawyer in advance, it would be great for them to prepare for the meeting. Then you don't pay for so much time just while they're looking through it's more efficient for them to be prepared for strategy and for the questions they need. I have another thought about saving money with an attorney, and it's one of those things that when you're going through divorce, there's so many emotional things going on, and you're really looking to people that you can trust to help you in it. And you should find an attorney who you can trust to help you, and you're going to need to connect with them. They need to understand your story, both so they can represent it and also so that you can feel that you're communicating with them and that you can trust them. But one of the pitfalls I want to warn us about is most of your emotional needs should really be met with family, friends, or a therapist. And the reason is your lawyer, even though they may be very capable of helping you with that stuff, their rates are much higher than therapists. Psychotherapy can cost, I don't know, anywhere from $50 to $250, maybe even higher per hour. And some of that may be even paid by insurance. But marriage and family lawyers can cost between $150 and over $1,000 per hour in Southern California.
Yeah.
And so, for those kinds of things, you want to, even though, as I say, you want to establish a relationship with your attorney, keep a check on how much of that kind of need is being met by your attorney as opposed to a less expensive option.
Yeah, that's great advice, because I think we would tend to, in the middle of this emotional chaos, start to just, open up and vent and dump with our attorney the emotional roller coaster that we're going on. And that isn't, like you said, the right person or the right time because of the cost. And it would be easy to have that conversation. I think it's very important that they realize, like you said, their story, and you feel comfortable knowing that they have your back.
Yeah.
But yes, getting help from a coach or a therapist, or, like you said, family and friends, other support groups, that's where you can dump, and that's where you can vent, and that's where you can just, let loose. So, cost per hour, yeah, absolutely. I think it makes total sense.
And a coach, that's a good example, because, for instance, a coach, one of the things that you do, I know, is coach women who have been through who are going through this kind of thing. And you've been through it before and know some of you and I have talked before, so I know you know some of the procedure and law that's going to be associated with it. So it's, you can provide kind of practical advice and help through those times as well.
Yeah, I think it's great. I think yeah, whatever kind of help you can get is priceless. There's no doubt. When should, you mentioned a minute ago, litigation. When should we consider mediation instead of litigation? And do we file for divorce first? Walk us through what that looks like.
Well, I think the answer to when you should consider mediation is really as soon as possible.
Okay.
Many of my clients come to me first before they even file for dissolution of marriage. And I can even help them through that initial filing, so it's not so stressful. Because they're both together, and we can plan when it's going to be served and what's going to be on the petition and response, so that it's not a big surprise and this dramatic thing. You can get through that first part easily. Some people come to me after they've gone through their first hearing. See, when you file for dissolution and you begin that process, the normal end of that is a trial. You've got to get it to a judgment somehow. So you can either make an agreement or you'll go to trial. But that trial takes a long time before you ever get to that point. So oftentimes, most times, if you aren't in mediation yet, you'll have a hearing. There will be a hearing planned where they will make temporary orders about support and custody, who's going to be responsible for the kids and how we're going to pay the family household expenses until we get to trial, where there's evidence and a final order. So sometimes they go through that first hearing and they're so surprised by how much it costs, and that they want to try something where they have a little more control and over both the procedure and the costs. Sometimes they'll go through that first hearing and realize that the court is not going to give either one of them a clear win. So they want to try mediation and see if a neutral professional mediator can help them find a solution.
Okay. You might have covered some of this, but my next question is the benefits of mediation as opposed to litigation.
Mm-hmm. Well, the feeling I have, or the the thing that I see, Patty, most is that mediation gives parties, gives spouses more control over the process and the expenses than litigation. Because litigation has a lot of deadlines, and lawyers really have to prepare. They're required to respond to those deadlines. In advance of a hearing or a trial, there are deadlines they have for gathering information through formal discovery and preparing evidence and submitting briefs, which is their facts and declarations and arguments for the law of supporting the position. So they have to do those kinds of things. There are mandatory settlement conferences with a judge. And so there's a lot of expenses that go into that have to be done if there's going to be a hearing. And every hearing, no matter how short it is expensive. Even if you're called to court for, let's say, an 8:30 a.m. hearing, you may not have your hearing or trial until hours later. Meanwhile, you sit in the courthouse and pay your lawyer to sit through other people's disputes until the court's ready for you.
Yikes.
I think a lot of people don't realize that. You think, oh, I have an 8:30 trial. It should take a couple hours. I'll be out by 10:30. It's not really that way. Now, in mediation, you set the schedule for what works for you. You can hire neutral joint experts, in mediation. So let's say you have a house that you need to get agreement on the value of it. You can hire a joint appraiser. Or if there is a custody issue that you need expert opinion on because you disagree, you can hire a joint expert to interview everybody and provide a report. And you also have privacy in mediation. The only thing, there's confidentiality in mediation, so none of the things that you prepare for mediation can be used in court, and they're not part of a public record. Whereas if you go to litigation, your finances, your concerns about custody, the behavior that you dislike in your spouse and the behavior they dislike in you is going to be filed as part of a public document. And I think that's really, people don't realize that's going to be the case, and it really is another reason to consider mediation, where you can keep control of your relationship, your information, your expenses, and your time.
Yeah, I think mediation is just such a great option. It keeps things so much calmer, keeps the emotional roller coaster down to a minimum, which if you have kids, they're absorbing, they're watching. We've got just a couple of minutes left, but I want to ask you one last question, and then I want to make sure we have time to share your information. You use the term date of separation. What does that mean, and why is that so important?
Well, it's one of the things you want to be ready when you first when you have your first appointment with your attorney. You want to be able to, you have to know what your date of marriage is, and you want to be able to discuss date of separation. Some people think, oh, well, the length of my marriage is when I was married until the date I was divorced. But the way California looks at it is the marriage actually is between the date of marriage and the date of separation. And the date of separation is the date that at least one of the spouses decided the marriage was over and took action consistent with that. Sometimes it's when they leave, they move out. Sometimes it's when they announce at the couples therapy, I'm done, this is over, this relationship's over. And that'll be your date of separation. And the reason that date is important is because it relates to the character of assets and debts and to the length of any support order that you'll get. The way property, debts, and assets is handled in dissolution is that things that are earned or acquired before the date of marriage and after the date of separation are presumed to be the separate asset or debt of the person who earned or acquired that. Between the date of marriage and the date of separation, everything earned or acquired by either spouse is presumed to be the community property of the spouses, with each spouse having an undivided 50% interest in it. So it has a lot to do with what property is yours, what property belongs to you and your spouse, and it will have some real effects.
Real important parts, yeah.
Also, date of separation, Patti, is one of those things where there's presumptions in the law about if a marriage has lasted longer than 10 years, there's a presumption that it's a lengthy marriage, and has something to do about how long they'll order support for. And
Penny,
so
I hate to cut you off. We're going to commercial real quick. Give me,
Okay.
we're going to actually have your contact information, and people can reach out to me. But give me a minute and share your information so that those can call you.
Okay, my name is Penny St. John. The name of my business is Conflict Resolution Management. My email address is penny@st-j.com.